Ms. Prince Polo, and it is time to look at a matter in Parliament. Yesterday, Parliament passed an amendment to the Computer Misuse Act 2022, a law that criminalizes sharing, publishing, and passing on information that is incorrect. And it comes amid concerns that this particular law will infringe on media freedom, and the law targets use of internet, especially online media users. We need to look into this particular law, its merits and demerits, and now that it only awaits assent of the president, hopefully we need to know what exactly it entails. And in the studios this evening, we have Mr. Alan Sempala Chigozi, and he is the head of legal department at Unwanted Witness. Alan, welcome to the show this evening.
Thank you, Apollo.
Let's go straight to the close publishing of information that is contrary to the laws of Uganda, and using a disguised or false identity, you also commit an offense. Tell us exactly what you think could be the risks in the use of social media in relation to this particular law, though it is not yet into force.
For starters, Apollo, it's a very dark day and a dark moment for freedom of expression in Uganda. This law, definitely, if assented to by the president, it will make the situation even worse. The principal act in its current state already is problematic. It has been too powerful and definitely had no place in a constitutional dispensation. It limits freedom of expression, and freedom of expression being the hallmark for any democracy. It's a tenet that has to be in place for us to enjoy any freedom of expression, to enjoy any democracy if we have it. But that's what at least the country is yearning to achieve, and to get to at least where Kenya is right now. The law, definitely, when Parliament invited us, we made our comments, and we told them definitely it had issues. Thank God, a few of them have been removed, like getting people out of office and preventing them from running for public office. It was discriminative. But again, many issues still stand. We believe that the law is superfluous. It is not needed. It's not needed. Already the existing laws provide for that. If I'm to share information, someone's personal information, without their consent, the Data Protection and Privacy Act provides for that.
Okay.
Ably well. And when I was reading the report of the committee, they were alluding to the fact that they didn't detail what gaps are in the Data Protection and Privacy Act, because we have a Data Protection and Privacy Act that provides for the use of personal data for anyone. If you are to use it, you need to seek their consent. It is detailed. Definitely, the Act in its Data Protection and Privacy Act has glaring loopholes and lacunas. So what I expected of the committee, at least to point out some of those gaps that they are coming to close or to fill up. You can't use one law to make amend of another law.
Okay.
You get my point. Already the law in its current state, the Computer Misuse and Computer Misuse Act, is draconian.
Let's look at a case of a journalist who has found someone maybe doing something that is newsworthy, and he captures the moment. Does that law, is his action in conflict with this particular law? Without seeking consent, of course.
No, definitely, as it stands right now, if they are sent to it, it will criminalize that.
Really?
So it's inimical to citizen journalism and free speech and any form of journalism. So for us, we think we would really hope that the president doesn't assent to this, because really the law is not precise. It's not clear. When you prohibit, sharing of that information, where do you leave journalism? Journalists who have to actually even counter those who are breaking other laws, like the traffic, the traffic and
so
road safety.
if I find, for instance, a public officer soliciting a bribe, I must first seek consent before I take a picture. That is what is in the law as it stands.
Exactly. This is what we are telling the committee in Parliament, that the law lacks clarity. It lacks clarity. Where a law lacks clarity, you can't get justice.
Okay.
What amounts to sharing that information that you need to seek information for? What amounts to hate speech? I'll take you first to what because the law specifically amended hate speech. What amounts, and who sits at the high altar of righteousness, to determine what is right and what is wrong? Okay? So it's not clear. And where a law lacks clarity, then definitely there will be lack of justice. So where do you leave journalists who have to actually report some of that information? Definitely someone you found getting a bribe, they want consent to you. So there need to be clear definitions. Okay. Like they went to an extent, an extra mile of defining social media. In the report, if you read the report, at least they defined social media. They detailed what amounts to social media, what pages are they talking about, what social media pages are they talking about, how it can be used. So should have been done for the other articles, the other sections of the act that they seek to amend. The same thing should have done for section 25 and 24, because we've been to court. We've been to court and asked them to define, to at least to pronounce themselves on those two sections. They are not as clear. They are ambiguous. They could have probably defined those sections. Maybe it would have been even clear what amounts to offensive communication. Okay. Because as it stands right now, they leave a lot of power to the enforcers to determine who has offensively communicated, who has done used what hate speech. You get my point. It's not defined.
I bring another scenario of someone who is using social media. A photograph or a written up message pops up and he shares it onto another platform or to a colleague. As the law stands, is that an offense?
No, as the law stands, definitely makes it an offense. But definitely, even before the amendment, the Data Protection and Privacy Act provided for you needed to seek consent from the owner of the photo or the owner of that personal information for you to use that personal information. You ought to. But again, like I told you, even the Data Protection and Privacy Act had glaring gaps. It was again also problematic to journalism as well, because I can't seek consent from you if I need to investigate a certain story from you. You get it? So that's why we've always called out the Office of the Data Protection Commission Director to come up with a framework, guidelines on how journalists can actually conduct themselves, by virtue of the act, because it's not clear. As it stands right now, the act doesn't specify who a data collector is. Okay. So for them, according to the act, anyone who collects any personal information, you're a data collector and you ought to register with them. We think that is very problematic. Now, on top of that, if you have this amendment of the communication, the computer misuse, the amendment bill, then it's even making it worse. It's making it worse. So that's why when I was starting, I told you that it's a dark day for freedom of expression, but also for freedom of speech and citizen journalism.
Well, you had your time in the committee to make recommendations. Does that mean that your recommendations were not captured?
They were not, definitely. They were not. I mean, we were so clear that we have enough laws to counter what the Honorable Sodoko was alluding to. Okay? We have the Data Protection and Privacy Act, but also Article 50 and Article 27 of the Constitution, read together with the Data Protection and Privacy Act and its regulation, and Section 3(9) of the Human Rights Enforcement Act. Those have enough remedies for anyone who considers that they have been demeaned, they have been used hate speech against them. You get it? We have enough remedies. Okay. So actually, the current Principal Act has been used to go against many people. You remember Stella Nyanzi, you remember Joseph Kabuleta. Those were charged under the same act.
The Computer Misuse Act.
Exactly. So it has been even more powerful. So what we've always requested our Parliament to do, and when we faced the committee, was that, look guys, the law needs to be made more clear. Many times in there are not so clear, so you leave a lot of power to the enforcement officers. And that's why you see that the Principal Act has been used against probably opposition people by the so-called powerful people. Okay. So you don't hear any case where a local person has used the Computer Misuse Act to go after anyone who has demeaned them. So it has only been used by the powerful when they think that they have been offended.
Okay. Finally, the law, in one of its objectives, is to introduce clauses that do provide protection of children, on information relating to children without authorization. Is that also covered in other laws?
It is.
Or it is something new that the law brings?
It is. Section 8 of the Data Protection and Privacy Act provides for that. If you ought to use personal information regarding a child, you ought to get consent from a parent. The regulations of the Act also in detail show how you could use that personal information. So bringing it in the Computer Misuse Act is laughable. That's
so you don't find anything new about this law? I mean about this amendment?
I only find an evil spirit that is meant to fight freedom of expression.
Really?
The Queen died, I think yesterday, and in Ireland and Jamaica, people are mocking the death of the Queen. I think those who have been on Twitter have seen the hashtag Liz.
Could that be treated as hate speech?
Exactly. Liz has been trending, and people have been mocking the death of the monarch, saying that the monarch was a cause of death of many of their descendants. They robbed their minerals, they robbed their riches, and many African countries are the way they are because that's their thinking. So if this regime was in Ireland, I guess everyone would be arrested and put in prison and made to pay 15 million or go for 5 years in prison. That is freedom of expression. In freedom of expression, you ought to guard those ideas that are not favorable to you, that you think are not pleasing you. In fact, it is meant to protect those ideas or opinions that you don't think favorable. You get my point? So you have to be tolerant. So
finally, in one or two statements, what would you refer to such a bill?
No, the bill, like I said, is superfluous. It's not needed.
Superfluous?
Yeah, it's not needed. It's not necessary. Our recommendation to the committee was, please don't consider it.
Okay.
Rather make the Data Protection and Privacy Act more stringent. It has glaring loopholes.
It has gone through the processes.
It has gone through.
It has been handled by the committee, and now the whole house, the committee of the whole house.
Well, I believe, for me, I believe our president is patriotic.
Okay.
He has sent back many bills that they have sent to him to assent to and asked them to amend. I believe in our president. He will send back that bill to Parliament, and they will make those amends, or even throw it away or trash it.
All right. Thank you so much, Alan Sempala Chigozi, the head of legal at Unwanted Witness. We were looking at the Computer Misuse Amendment Bill, now Act of Parliament, awaiting the assent of His Excellency the President. Hopefully, we will be. It is now in the hands of His Excellency the President to decide whether it goes into force or it comes back for revision in Parliament or elsewhere. My name is Timapolo, and that is Limelight. We'll be back next Friday. Good evening and a splendid weekend.